They thought they could steal 3 acres of my family's land with a fake document. What they didn't know was that I used to work for the district attorney. By the time I was done with them, their entire board was facing criminal charges, and their precious HOA was bankrupt. Hey, I never thought I'd be sharing this story, but what happened to my family was so outrageous that I need to warn others about what HOAs can try to get away with. 5 years ago, my wife and I bought our dream property, a beautiful 5-acre lot on the edge of a developing community. We specifically chose it because most of it wasn't part of the HOA territory. Only our driveway and the front portion near the road were included. The rest, over 3 acres of pristine woodland, where we planned to build a workshop, a garden, and a play area for our kids, was completely ours, free and clear. Or so we thought. What followed was a 2-year nightmare that nearly cost us everything we owned. But through persistence, careful documentation, and a bit of luck, we didn't just defend our property, we took down the entire corrupt HOA that tried to steal from us. It all started with a letter. Not even a certified letter, just a regular envelope with the HOA logo stamped in the corner. Inside was a notice claiming we were in violation of HOA regulations because we had started clearing trees on community property. The letter stated that all 5 acres of our land were subject to HOA regulations, and we needed to immediately cease all work and pay a $500 fine. I remember laughing when I read it. I had the deed and property survey right in my filing cabinet. We had specifically asked our real estate agent and the previous owners about the HOA boundaries, and they had shown us exactly where our independent property began. We had even checked with the county records office before buying. So I wrote a polite response, attaching copies of our deed and the property survey clearly showing the boundaries. I explained that only the front portion of our land fell within HOA territory, and the area where we were clearing trees was well beyond that boundary on our private property. A week later, I received another letter, this time from the HOA's lawyer. The tone was much more aggressive. They claimed that the original developer had amended the HOA charter 10 years ago to include all properties in full and that our deed was outdated. They attached what looked like an official document, showing that all properties in our development had been fully incorporated into the HOA territory. The fine had now increased to $1,000, and they threatened legal action if we didn't comply within 30 days. This is when my stomach first started to knot. Something felt very wrong. The document they sent looked official, but why hadn't this come up during our property research? Why hadn't the real estate agent or the previous owners mentioned this amendment? I called our real estate agent, who was as confused as I was. She had never heard of this amendment and insisted that our understanding of the property boundaries was correct. The previous owners, when we reached them, were equally baffled. So I did what any concerned homeowner would do. I went to the county records office to check for myself. And that's when I discovered the first red flag. The amendment the HOA had sent us wasn't in the county records. According to all official documents, the HOA boundaries were exactly as we had originally understood, limited to just the front portion of our land. But the HOA wasn't backing down. When I sent them the county's confirmation of the boundaries, they claimed the amendment had been approved, but not yet properly filed with the county. A clerical error, they said. They insisted we were still bound by it. By this point, my wife was getting anxious. We had already spent thousands of dollars on materials for our workshop, and the contractors were scheduled to begin construction in 2 weeks. The last thing we needed was a legal battle with our HOA, but something about this didn't add up. If this amendment was legitimate, why wasn't it properly recorded? And why were we only hearing about it now when we started developing the back portion of our property? I decided to dig deeper. I contacted other homeowners in our development to see if they had heard about this amendment. Most had the same understanding we did, that only portions of their properties fell under HOA jurisdiction. None had ever been told that the entire development had been brought under HOA control. Things got even stranger when I spoke with Mrs. Jenkins, who had lived in the community for over 15 years. She had served on the HOA board around the time this alleged amendment was created. According to her, there had never been any discussion of expanding HOA territory to include all property boundaries. In fact, she specifically remembered discussions about keeping the woodland areas free from HOA control to attract buyers who wanted more land independence. That's when I realized we weren't dealing with a misunderstanding. Something more sinister was happening. I needed to understand what we were up against, so I started researching the current HOA board members. Our HOA was run by 5 people: Robert Kellerman, president; Susan Whitfield, vice president; Michael Brooks, treasurer; Patricia Donovan, secretary; and Thomas Green, member at large. Robert Kellerman had been president for 6 years. He lived in the largest house in the community, a sprawling mansion on the north side. During the day, he was a real estate developer who specialized in luxury properties. Susan Whitfield was a retired corporate lawyer who had moved to our community 3 years ago. Michael Brooks owned a local construction company. Patricia Donovan was a stay-at-home mom who had previously worked in banking. Thomas Green was the newest board member, a retired engineer who mostly kept to himself. What struck me as odd was that all 5 board members lived on the perimeter of the development, with properties similar to ours. Larger lots with portions that supposedly fell outside HOA boundaries. Yet none of them had ever been cited for HOA violations on their back acres. In fact, I knew for a fact that Michael Brooks had built a large workshop on his back property 2 years ago, and Thomas Green had a greenhouse that would have violated HOA regulations if his entire property had been under HOA jurisdiction. Were there different rules for board members, or was something else going on? I decided to start attending HOA meetings to get a better sense of how they operated. The first meeting I went to was eye-opening. I wasn't the only homeowner with complaints. Several people were protesting excessive fines for minor violations, while others complained about selective enforcement of rules. There was obvious tension between the board and many community members. During this meeting, I carefully observed the board members. Robert Kellerman dominated the conversation, often cutting off homeowners mid-sentence. Susan Whitfield cited HOA bylaws with practiced precision whenever someone questioned a decision. Michael Brooks remained mostly silent, occasionally whispering to Robert. Patricia seemed uncomfortable, especially when discussions became heated. Thomas Green looked bored throughout, checking his watch frequently. After the meeting, I approached Patricia, who seemed the most approachable of the group. I casually mentioned our situation and asked about the amendment. Her reaction was telling. She looked genuinely confused and said she wasn't familiar with any amendment expanding HOA territory. When Robert noticed us talking, he quickly came over and pulled Patricia away, saying they had urgent business to discuss. That night, I couldn't sleep. Why would the HOA president and their lawyer insist on an amendment that the secretary didn't even know about? And why were they so interested in our back property specifically? I decided to look at satellite images of our development using Google Earth. Our 5 acres were heavily wooded, with a small stream running through the back. The properties on either side of ours were similar, large lots with woodlands. But when I zoomed out to see the bigger picture, something caught my eye. Beyond our row of properties was undeveloped land that, according to county plans, was slated to become a new shopping center. The only thing separating this commercial zone from our community was the strip of woodlands that included our back 3 acres and similar portions of neighboring properties. Then it hit me. If the HOA controlled all these woodland areas, they could potentially sell or lease access rights to the developers of the shopping center, creating a new entrance through what we thought was our private property. This would significantly increase the value of the commercial land by providing direct access to our community roads. The next day, I called the county planning department and asked about the shopping center development. The clerk mentioned that there had been delays because of access issues. The developers needed another entry point besides the main highway. They had been in negotiations with local property representatives about creating a secondary access road. Could those local property representatives be our HOA board? I needed more information. I reached out to a friend who worked at the county clerk's office. Not officially, just a casual conversation over coffee. I asked if she knew anything about development plans in our area. "Oh, you mean the Westridge Shopping Plaza," she said. "Yeah, there's been lots of back and forth about that." Originally, they couldn't get approval because of single access concerns, but I heard they recently resolved that. Something about a secondary access road through existing residential areas. My heart sank. Do you know who they've been working with to arrange this access? She thought for a moment. I'm not sure, but I remember seeing Robert Kellerman at the planning office a few times. Isn't he your HOA president? That was all the confirmation I needed. Robert and possibly the entire board were planning to use HOA authority to seize control of our back acres, not for the benefit of the community, but to sell access rights to commercial developers. But I still needed proof. Without hard evidence, it would be our word against theirs. I decided to take a risk. I contacted David Chen, who lived 2 doors down from us and also had a large wooded lot similar to ours. David worked in IT security and was known in the neighborhood for being tech-savvy. I shared my suspicions with him, and he was immediately concerned. He had received a similar violation notice about clearing trees on HOA property. David suggested we dig deeper into the HOA's financial records. As homeowners, we had a right to review them, though the HOA made the process deliberately difficult. We submitted a formal request, and after much delay and many excuses, we were finally allowed to review the records, but only for 30 minutes under supervision and without making copies. David and I went together. While I distracted the HOA administrative assistant with questions about upcoming community events, David quickly photographed as many documents as he could with his phone. What we found when we reviewed those photos was shocking. There were unexplained transfers from the HOA account to a company called Westridge Development Partners, LLC. Over the past year, nearly $50,000 had been paid to this company for vague consulting services. A quick search revealed that Westridge Development Partners was registered to Sarah Kellerman, Robert's wife. Even more damning was an email printout we found in the financial folder. It was from Robert to the other board members, discussing the boundary expansion strategy and mentioning potential significant revenue once they secured full control of the buffer zone properties. The email specifically mentioned our address and 2 neighboring properties as Phase 1 priorities, because we were actively developing our rear lots. This explained why they had targeted us now. Our tree clearing activities had accelerated their timeline. They needed to assert control before we built permanent structures that would complicate their plans for an access road. Armed with this information, I consulted with a real estate attorney. After reviewing our evidence, she was confident that the HOA's claims were fraudulent. The amendment they cited didn't exist in any official capacity, and their attempt to enforce it constituted both fraud and potentially criminal misrepresentation. But she warned us that legal battles with HOAs can be long and expensive. HOAs often have substantial legal funds and can drag out proceedings until homeowners give up or go bankrupt. We would need to be prepared for a fight. That's when I remembered something from my past that would change everything. Before moving to this community, I had worked as a paralegal in the district attorney's office for 7 years. I specialized in property fraud cases and had maintained good relationships with several investigators and attorneys there. If what the HOA was doing constituted criminal fraud rather than just a civil dispute, the DA's office might take an interest. I called my old colleague Mark Ramirez, who still worked as an investigator for the DA. I explained the situation and sent him copies of everything we had gathered. Mark was immediately interested, especially when I mentioned the connection to the shopping center development. This sounds like more than just HOA overreach, he said. If they're falsifying official documents to seize property control for financial gain, that's criminal fraud. And if they're using HOA funds to pay a company owned by the president's wife, that could be embezzlement. Mark agreed to look into it quietly. He cautioned that the DA's office wouldn't get involved in a simple HOA dispute, but if there was evidence of criminal activity, they would investigate. While Mark was doing his research, we received another letter from the HOA. The fine had now increased to $2,500, and they were threatening to place a lien on our property if we didn't pay within 15 days. They also enclosed a cease and desist order, demanding we halt all development on our back acreage. This was their biggest mistake. By issuing a formal cease and desist based on fraudulent claims, they had crossed the line from threatening to actual legal action based on falsified documents. Our attorney advised us to respond officially through her, denying their authority and demanding they withdraw their claims or face counter-legal action. The HOA's lawyer responded with even more aggressive threats, claiming they would not only enforce the lien, but would also seek court costs and legal fees when they prevailed. They attached another copy of the supposed amendment, this time with what appeared to be official county stamps and signatures. I immediately sent this new document to Mark. 2 days later, he called me back, his voice urgent. "Don't respond to anything else from them," he said. "The document they sent you is a forgery. Those are not valid county stamps, and the signature of the county clerk is definitely fake. We're opening an official investigation." Things moved quickly after that. The DA's office subpoenaed the HOA's records and froze their accounts pending investigation. They also obtained warrants to search the homes and offices of the board members. The evidence they uncovered went far beyond what we had imagined. Not only had Robert and the board forged documents to try to seize control of our back acreage, but they had been engaged in multiple fraudulent schemes. They had been selectively enforcing HOA rules, waiving fees for friends and family while aggressively fining others. They had embezzled over $200,000 from the HOA reserve fund through fake invoices to companies they controlled. They had already signed a preliminary agreement with the shopping center developers, promising access rights through our properties in exchange for $1.5 million. Money that would have gone to the board members personally, not the HOA. They had falsified meeting minutes and election results to maintain control of the board for years, preventing other homeowners from taking leadership positions. The case against the HOA board moved from the investigation phase to prosecution surprisingly quickly. The district attorney's office found the evidence so compelling that they fast-tracked the case. Within 3 months, all 5 board members were facing multiple felony charges, including fraud, forgery of official documents, embezzlement, and conspiracy. But the most dramatic moment came during the preliminary court hearing. We had been advised to attend, as our property was central to the case. The courtroom was packed with homeowners from our community, most of whom had no idea what had been happening behind the scenes. As we sat in the gallery, Robert Kellerman and the other board members were brought in. They looked nothing like the confident, authoritative figures who had ruled our community with iron fists. Robert's face was ashen, and Susan Whitfield, usually so composed, couldn't stop her hands from shaking. The prosecutor, a sharp woman named Jessica Martinez, whom I had worked with years ago, laid out the case methodically. She projected the forged amendment on a screen, pointing out the inconsistencies and obvious signs of tampering. She showed bank records documenting the embezzlement, and then, in the moment that caused an audible gasp in the courtroom, she played a recording. It was from a hidden microphone worn by Patricia Donovan, the HOA secretary, who had turned state's witness in exchange for leniency. The recording captured a board meeting that never appeared in the official minutes, where Robert explicitly discussed their plan to seize control of the back properties. "Once we have the access road agreement finalized, we'll be set for life." Robert's voice rang clearly through the courtroom. "The idiots who bought those properties have no idea what that land is really worth. We just need to keep pushing the boundary issue until they give up." Michael Brooks could be heard laughing. "Or until they go broke fighting us. The HOA has deeper pockets than any individual homeowner." Susan Whitfield's voice added, "The beauty of this is that even if they check with the county, there's no record of our amendment yet. We can claim it's a filing delay. By the time anyone figures it out, it'll be too late." As the recording played, I watched the color drain from Robert's face. He glanced back at the gallery, his eyes meeting mine for a brief moment, before looking away in shame. The judge's ruling was decisive. All board members except Patricia would be held over for trial, with bail set at $500,000 each due to flight risk concerns. The HOA's accounts would remain frozen, and a court-appointed administrator would take over community management until a new board could be properly elected. As the defendants were led away, Robert's wife, Sarah, who was sitting a few rows ahead of us, turned and glared at me with pure hatred. "You've ruined everything," she hissed. "You could have just paid the fine and moved on." That's when I realized how accustomed they had become to people backing down, to homeowners paying unfair fines rather than fighting back. They had created a system of intimidation so effective that they never expected anyone to challenge them. Certainly not successfully. Outside the courthouse, reporters from local news stations were waiting. The story had attracted significant attention. Corrupt HOA officials facing felony charges wasn't something that happened every day. One reporter thrust a microphone toward me, asking how it felt to be the homeowner who brought down the corrupt HOA. I thought carefully before answering. "This isn't about one homeowner or one property dispute," I said. "This is about abuse of power and betrayal of trust. These people were elected to serve our community, not to exploit it for personal gain. I hope this case sends a message to HOA boards everywhere. You work for the homeowners, not the other way around." The aftermath was both vindicating and chaotic. With the HOA effectively dissolved pending reorganization, our community entered a strange limbo. The court-appointed administrator focused only on essential services like common area maintenance, while everything else, architectural approvals, rule enforcement, fee collection, was put on hold. For us, this meant we could finally continue developing our back acreage without interference. We resumed construction on our workshop and began planting the garden we had envisioned when we first bought the property. But the real satisfaction came 2 months later when the criminal trial began. By then, the prosecution had gathered even more evidence. Thomas Green, the retired engineer, had also turned state's witness, providing detailed documentation of how they had systematically targeted specific properties and fabricated violations. The trial lasted 3 weeks. Each day revealed new depths of corruption and greed. We learned that this hadn't been their first attempt at this scheme. They had successfully intimidated 2 other homeowners into selling portions of their land to the HOA at below market rates using the same forged amendment tactic. The jury deliberated for less than 6 hours before returning guilty verdicts on all major counts. Robert Kellerman was sentenced to 8 years in state prison. Susan Whitfield and Michael Brooks each received 5-year sentences. Patricia Donovan, due to her cooperation, received probation and community service. Thomas Green, also for his cooperation, received a suspended sentence and probation. But the criminal convictions were just the beginning. The court also ordered them to pay restitution to the HOA for all embezzled funds, plus punitive damages. Their personal assets were seized to satisfy these judgments, and then came the civil suits. With the criminal convictions establishing clear wrongdoing, our attorney advised us and other affected homeowners to file civil lawsuits for fraud, harassment, and emotional distress. Given the overwhelming evidence and criminal convictions, these cases were essentially open and shut.
The court awarded us $350,000 in damages, plus all legal fees. Similar judgments were granted to other homeowners who had been victimized by the corrupt board. With their personal assets already depleted from the criminal restitution, these civil judgments effectively bankrupted all the former board members. The shopping center developers, once they learned of the fraud, immediately backed out of all agreements and distanced themselves from the project. They issued public statements claiming they had been misled about the property boundaries and access rights. Whether this was true or they had been complicit all along, we'll never know for certain. It's been 3 years since that court case. Our community has healed and transformed in ways I never expected. After the dust settled, we held new elections for the HOA board. I was asked to run, but I declined. I had seen firsthand how power could corrupt, and I had no interest in taking on that role. Instead, I helped draft new HOA bylaw that included strict transparency requirements, term limits for board members, and checks and balances to prevent any future abuse of power. We created a system where financial decisions above a certain threshold required community-wide votes, and all documents were digitized and made available to all homeowners at all times. Mrs. Jenkins, who had been on the board years ago before the corruption set in, agreed to serve as interim president until we could establish the new system. Under her leadership, the community began to rebuild trust. As for our property, we finally completed everything we had dreamed of. The workshop now stands at the edge of our woods, where my wife pursues her woodworking hobby. The garden flourishes in the summer, providing vegetables for our family and several neighbors. And the play area for our kids has become a favorite gathering spot for neighborhood children. The wooded areas that the corrupt board had coveted have been preserved. In fact, the new HOA established a conservation easement covering all the woodland portions of properties in our community, ensuring they can never be developed or sold for commercial purposes. What was once seen as valuable real estate to be exploited is now protected green space for generations to enjoy. Robert Kellerman, Susan Whitfield, and Michael Brooks are still serving their prison sentences. I heard that Robert's wife Sarah had to sell their mansion and move to another state after the financial judgments wiped out their savings and assets. Patricia Donovan completed her community service and moved away, reportedly to start fresh in another city. Thomas Green still lives in the community, largely ostracized but occasionally making efforts to make amends for his role in the scheme. The shopping center that was planned for the adjacent land was eventually built, but with its only access from the main highway, exactly as the original plans had specified. It's actually been a convenient addition to our area, providing shops and restaurants within walking distance, without disrupting our community or destroying our woodlands. What happened to us wasn't just about property boundaries or HOA regulations. It was about power, greed, and the assumption that ordinary people won't fight back against those who abuse their authority. They thought we would be easy targets, that we would either pay their fraudulent fines or sell our land rather than endure a prolonged legal battle. They underestimated not only my determination and background, but also the power of community. Once other homeowners realized what was happening, they rallied behind us, sharing their own stories of intimidation and unfair treatment. What the corrupt board never understood was that the very community they were exploiting would ultimately be their downfall. If there's a lesson in all of this, it's that homeowners associations, like any institution, are only as good or as corrupt as the people who run them. HOAs can provide valuable services and protect community standards, but they can also become vehicles for abuse if left unchecked. For anyone dealing with an HOA dispute, my advice is simple. Know your rights, keep meticulous records, and don't be intimidated. Most HOAs operate honestly and in the best interests of their communities. But for those that don't, remember that their power ultimately derives from the homeowners they serve. They are not above the law, and they are not unbeatable. Our case was extreme. Most HOA disputes don't involve criminal conspiracy and fraud. But the principle remains the same. Unjust authority only persists when people are afraid to challenge it. We weren't just fighting for our 3 acres of woodland. We were fighting for the principle that no one, not an HOA board, not wealthy developers, not anyone, has the right to take what isn't theirs through deception and intimidation. In the end, we didn't just save our land, we saved our community. If you've experienced HOA injustice, share your story below.